Good morning, Senate Judiciary, February 1st. Senator Sears is just a bit late joining us, but we are going to be getting started on S-166 and our first witness, who is Maria Royal from Ledge Counsel. And I believe Maria is going to walk us through an amended draft. And so Maria, if you'd like to share your screen and do that, and then hopefully Senator Sears will join us in process.
Great, I'm happy to do that. Is this now visible to everybody?
Yep. Yes.
Okay, so this is draft 1.2 of a Judiciary Committee amendment. And hopefully it reflects some of the decisions that you made when we last spoke last week. So we'll walk through each of those. That's not a very long bill, so it shouldn't take too long. But the first change was initially, as introduced, the bill required the PUC, the Public Utility Commission, to go through a rulemaking process to address issues about cleanup of broadband construction work sites. And you, after hearing some testimony, decided you would rather make it a statutory requirement and bypass that rulemaking process. So that's the first big change. So this is a statute, 208C, which is in Title 30. And to kind of clarify legislative intent with respect to the requirements in this section, I added a purpose section, which is subsection A. And that states that the purpose of this section is to protect the general public from harm or injury caused by unsafe practices on broadband construction work sites. So then in subsection B, this is kind of the meat of the bill, if you will, with respect to the requirements. One of the other decision points that you addressed last week was the scope of the requirement. So initially you had heard testimony about utility poles having to do with kind of electric providers and whether you wanted it to apply generally to any work on utility poles, electric or communications. And you made the decision, I believe, to narrow the focus to broadband installations on utility poles. So that's the reference to Rule 3.700. That rule covers attachments to utility poles by telecommunications providers. It's even further narrowed in the sense that it applies specifically to fiber optic attachments. So just to be fully clear, I'm just going to read the first sentence, which is kind of long, and I'll give a little explanation to make sure this is consistent with what you wanted. So an attaching entity subject to Commission Rule 3.700 that seeks to attach fiber optic cable to a utility pole shall ensure that all construction contracts for such attachments contain terms and conditions specifying standards and responsibility for the safe disposal of any debris on the construction worksite. So just to clarify, 3.7 does apply to all kinds of telecommunications attachments. It could be wireless, antenna, could be DSL, could be cable from a cable company, coaxial cable. But this is limited just to fiber. And that was, I think, reflects the testimony you heard, which had to do with fiber strands, fiber cable being left on site, particularly on agricultural land. Also, just as kind of background, the broadband money that you appropriated last year, and a lot of the construction that you're going to see over the next 5 years, 5 or more years, is fiber optic cable. So this is an area where there will be a lot of deployment, and this is a statute that addresses specifically practices around that deployment.
Maria,
Yes.
if I could, and I'm remembering our discussion as well. So as I remembered it, we were talking about electrical work as opposed to the work that would be covered under 3.7. So there was 3.5 originally, and then we moved to 3.7. So by moving to 3.7, we narrowed, it seemed to me, what was in the original language. Here we're narrowing further by saying fiber optic cable. So I'm wondering, since we're specifying an attaching entity subject to 3.7, I'm wondering why we would not then leave it for any attaching entity with whatever, you know, hazardous or, you know, I don't know what to call it, but any material that gets left behind. So for instance, you mentioned, you know, DSL or cable. If pieces of cable get left on the ground under this, there would be no redress, right?
Correct.
So that's how about other committee members? What is your memory about what we were looking for in this language?
I honestly can't remember.
Okay.
But it seems that this is so narrow that I don't know. I can't remember.
Why don't Maria, why don't we flag line 13? Because that's the place really where we further subdivide attaching entity. And when Senator Sears gets back, the committee remembers, I'm sure, that this is headed to finance.
I'm here.
After we're done with it. Oh, there's Senator Sears.
Yeah. Thank you, Senator Bruce. I'm here.
Yeah.
I just may not
Dick,
appear to be all here.
We're looking at.
No, I've got the conversation. I've been here for a few minutes. Yeah, I think we've overly narrowed it, frankly.
Okay, and just to be perfectly clear, you did not give me the direction to narrow it this far. I don't think you made that decision, which is in part why I wanted to spend so much time explaining how narrow it is, because I wasn't sure if that's what you wanted to do or not. So no, I think if you went back and looked at the testimony, you didn't say narrow it so much to fiber. So you could certainly strike that and make it apply to all of the attaching entities. So I made a note of that, and however you decide to proceed is fine, obviously. So now on line 16, it specifies that unless a contract specifies otherwise, the attaching entity is liable for all accidents, environmental cleanup, damages, or injuries to any person or property resulting from a failure to safely dispose of debris on the construction work site. And this is very similar to what was in the bill as introduced. I think it acknowledges that the testimony that you heard from FX Flynn, that most contracts have provisions related to performance, insurance, et cetera. And this recognizes that it's hard to kind of apportion liability in advance, but the contracts have to do that themselves. And then this is a fallback if there is an oversight and it's not specifically addressed. So then moving to subsection C, in addition to any other applicable penalties or remedies, a person who violates the safety standards required by this section commits an unfair and deceptive act in trade and commerce in violation of 9 VSA 2453. That is a reference to the Consumer Protection Act. And then it further clarifies, there was one comment that I received from the Agency of Agriculture, which I actually thought was a good one and very consistent with what you're doing. But and it also reflects some of the conversation that you had last week. So a clarification that a person who sustains damages or injury as a result of such violation is a consumer for purposes of the Consumer Protection Act, which is Title IX. So I think that's a clarification. So all of the enforcement machinery that comes with the CPA, the enhanced penalties, the possibility of receiving attorney's fees for a prevailing plaintiff, all of those apply, as well as the Attorney General's authority to investigate or bring an action on behalf of a consumer. And then in terms of the effective date and the application of this section, this act shall take effect on passage and shall apply to all construction contracts in effect on or after the effective date of this act. And then the final change is just to amend the title to make it reflect where what your intention is. So the title is amended to read an act relating to broadband construction work sites and consumer protection, as opposed to the broader utility construction, I think was the initial. So I'll stop sharing my screen so you can, if that's appropriate, so that you can have a discussion.
That'd be good. Senator Benning.
Maria, the term attaching entity, is that defined in Rule 3.7?
Yes.
And can you tell me what that is?
Yep. So it's basically, I can pull it up and look at it more closely, but it's basically any telecommunications provider or any provider. It could actually be an electric company if it's attaching broadband fiber, for example, which is something that is happening. So in the state. So it's any entity that seeks to attach communications facilities, whether it's wire or wireless, to an existing utility pole that could be owned by the telephone company, an electric company, or could be jointly owned by both.
Okay. I'm just trying to dovetail with the term fiber optic cable to figure out if there is an entity that is trying to correct the pole, but is not exactly attaching cable. Is there construction debris that comes from some other kind of attachment? And if that attaching entity is limited to those subject to Rule 3.7, are we missing something? I mean, the purpose is to protect the public from harm by any unsafe practices on broadband construction work sites. And I'm worried about any potential limitation that would prevent somebody harmed in the event it wasn't necessarily somebody subject to Rule 3.7.
So off the top of my head, I'm not aware of who else would be doing an attachment that's not a communications facility. Obviously, the electric company could be attaching electrical service and wires, which is a different issue. But other than that, in the scope of potential attaching entities that are not a communications provider or a contractor attaching communication service, I'm not aware. So I would need to ask a little bit more because nothing's springing to mind what that might be.
Okay.
Other questions for Maria? Um,
Can I just ask a question?
Senator Nitka, sure.
So I'm just wondering, so the only entity that we can think of that would be exempt from this would be electric companies. Is that true?
If we widen it a little.
Yeah, if you widen it, I believe so, but that gets to Senator Benning's question. I'm not sure what other attachments, if it's not from a communications provider or an electric utility, related to the electrical service. I just don't know.
I mean, we've never heard of a problem from, have we ever heard of a problem from a electric like GMP or Washington Electric or any of them? I've never heard of problems from them.
Well, just because, I mean, when looking at it, that it's going to be retroactive. I mean, I have a lot of power poles on my property, including the big 345 line, which is the double thing. And certainly I'm not worried about, I don't know how many animals grazing there, but there could be. But they certainly, looking
We
back.
have raccoons grazing.
Looking back,
You have raccoons grazing there.
looking back retroactively, there's a lot of junk under the poles, right where the poles are.
Oh,
Parts of
Okay.
old poles, there's all kinds of stuff.
Mhm.
So looking at it retroactively, I don't know.
all right. Jackie, did you want to comment?
Thank you, Senator Sears. For the record, Jackie Folsom from the Vermont Farm Bureau. I think the reason we were keying in not on the electrical lines, but the fiber optic is because it's the fiber optic lines that are wrapped with that wire that I showed you.
I see.
The wire is what was left on the fields. I don't have any information from any of my members or any farmers that I've heard of about the things left after electrical workers have left, except for Lauren Gitlin, whom you heard with the problem with her goats. But what we were looking at primarily was the fact that these wires, once they hang them, they are then wrapped with the wire that I showed you that got left on the fields and put it into inadvertently got put into the field. So that was our focus. And I'm not sure if I don't know if cable has to be wrapped, but it was the fiber optic piece that showed up with the wrapping of the wire that we're concerned with at this moment. So I don't have any background on electrical issues, and I don't have any background on whether the other wires are wrapped with this wire that we're so concerned about.
Unfortunately, I missed your testimony, Jackie, and but I trust that basically if we expand it to communications companies, then we're covered for everything except the electrical, I believe.
I
Your
would think so.
telephone, your cable, your broadband, anything else.
And I think, if I may, and so Jackie, maybe you can confirm this. I think what happened in Tunbridge, were they overlashing the fiber onto an existing wire? I think that might have been the wire that was then holding the new fiber to an existing strand, maybe of a copper wire or telephone, right? They used
Yes.
that wrapping wire
Right.
to hold it on. So there was some overlashing going on. And it's I think that was the wire, the excess strands that was left.
In many places besides Tunbridge, but yes, you're right.
Right.
Maria.
Mr. Chair?
Yeah.
I'm wondering, in Maria's draft, if right now it says an attaching entity that seeks to attach fiber optic cable, if we just eliminated fiber optic so that it just said seeks to attach cable, would
Mhm.
that draw in everything else?
So I'd look for the right term, whether it's wire or cable. And so if you said cable, and this is maybe a point of clarification, the other attaching entities that might not be covered under cable would be wireless technology, like an antenna. I don't know that you're concerned about that. If you want to include, that type of construction, or if you're focused really on the wires, fiber,
What if we
coax.
said wire, cable, or equipment?
Yeah, or even an attaching entity that seeks to attach, and I could look exactly, in fact, maybe while you're discussing, I'll look up the term that's used. Any attachment, basically,
Yeah.
pursuant to that rule. So,
Could you just put a period behind, I mean, just leave off that seeks to attach to the
Right.
pole, just,
yeah,
yeah.
Aye.
Was it our intention to limit it to only those entities that are subject to Rule 3.7? I know that's what the originating problem was targeted at that given entity, but I'm just wondering if somebody practices bad behavior that's attaching to a pole and yet is not an entity subject to Rule 3.7, why would we want to relieve them from this language?
I thought the PUC and the other testimony that we had was that 3.7 was.
We can't hear you.
to direct us to. Oh,
We can't hear you, Philip. There's a lot of interference.
interference. Can you hear me now?
No.
I don't even have a headset.
You sound like a staticky
Yeah.
radio.
Well, hopefully Senator Baruth will be back shortly. Yeah, we're still talking about cable companies, Wilda. There's Senator Baruth.
How's that? Can you hear me?
That's much better. You just improved.
Great. I thought that the testimony we had from the various stakeholder groups was that 3.7 was the place to target this. And that, the testimony we had about the chemical with the electrical work, we weren't gonna go that route. That was my memory, was that we sort of, and maybe we have Kyle Landis Marinello here. I'm remembering his testimony, I think, on this.
Mhm.
Dick, do you want to see if
Kyle, would you like to weigh in on this?
Sure, I'm happy to. Thank you, Mr. Chair. Again, Kyle Landis Murnello, General Counsel at the Public Utility Commission, and I do think there's a benefit to referencing attaching entities subject to Commission Rule 3.700, because there are all sorts of other provisions about attaching to utility infrastructure that apply under 3.700. It is worded very broadly. The language is this rule governs the attachment of lines, wires, cables, or other facilities by any attaching entity. Attaching entity is worded very broadly as an entity holding a certificate of public good from the Commission, or a broadband service provider that seeks to attach to a facility. And there's more to it, but it does kind of capture those entities that are attaching currently to utility poles. And I think the change that was discussed of just removing the words any fiber optic cable, that would be fine. That's consistent with what we would be looking at, just would apply more broadly to anything that's being attached if those words get removed.
Thank you. That's helpful.
Can I ask a
Senator
question?
Nitka. Yeah, sure.
Kyle,
Of Kyle or, yeah, okay, go ahead.
could you speak to the issue of if it were made retroactive, what would be the implications there in terms of all those other entities? telephone, etc.
I could try to do that. I guess so that's it, reading the current language that's in the draft because it's applying to current contracts. If that's what you're saying, that might apply retroactively. I think that that could cause some people to look at and see what's currently covered under contracts. Do contracts need to have this language added? I don't know how it would work in terms of work that was done under a previously valid contract, but now if this law is saying, well, no, those contracts have to have these additional requirements on worksite cleanup, I don't know the answer to that if that were to how that would play out.
Thanks.
Chair or anyone, where else do we do retroactivity in law? In general, we have statute of limitations, but usually if we change the law, for example, a certain chemical is now banned, do we make it retroactive? Don't think we do.
Yeah, so I would have to research that. I know I've worked on retroactivity provisions specific to insurance contracts, but just in general, hazardous materials being banned, and I'd have to do a little research on that for examples.
I think making it effective on passage is probably enough without complicating what that means.
Yeah.
Senator Benning.
I'm not sure why this is bothering me, Senator Sears. Line 17 talks about environmental cleanup. If I understand Kyle correctly, Rule 3.7 would not require cleanup of a chemical spill in that operation. And I don't know whether I'm overreaching here or what, but it just seems odd that we would try to make sure they pick up wire or bits of construction debris, but not hold them liable as well for chemicals.
Anybody got an answer for that?
Mr. Chair, I could
Yeah.
try to, I guess maybe I'm not seeing that, Senator Benning. I see the language that Maria has drafted as being quite broad in terms of saying the attaching entity is liable for all accidents, environmental cleanup, damages, or injuries. So I think if there's the question we were talking about who qualifies as an attaching entity, but once you qualify as an attaching entity, you have to have these worksite cleanup standards and contracts, and you're liable for any harm that's caused as defined under the statute. And so I guess that I see that as capturing a chemical spill that someone might have on the facility. But Maria, maybe you can chime in on that as well.
I would agree with Kyle. It's very broadly written. So it's basically any communications provider, any of the construction work that they do, if it causes an injury, that's really broadly defining, but there has to be some injury or damage related to the failure to properly clean up a work site. And it could be any debris or materials left behind.
Okay, I'm just trying to make sure nobody escapes any liability. And I read the entity subject to Rule 3.7 you're going to have to assume that any chemical spill is going to be connected in some way to somebody subject to Rule 3.7. If you guys are comfortable with it, I'll let it go.
I'm comfortable.
I am as well, and it will go to finance, I guess, right, Mr. Chair?
Yeah.
So we'll have another set of eyes on it as well.
Okay. Any further questions for Maria or Kyle or any? Karen Horn is here. I don't know if she's here for this one or for another one. And Jackie's still here. So. Okay. When do you want to get back together on this bill?
Whenever you can fit it in.
Dick?
Well, I think we could fit it in on Thursday at 10 a.m.
After 254 markup.
Yeah, well, we do that from 9 to 10 and then 10:30 to
10 to 10:30.
Yeah.
And is, Maria, is there something in about retroactivity or not? What are we proposing here?
Well, here, well, maybe can I share my screen? We'll just look closely at the language. So I think maybe in terms of how it could be construed as retroactive is that it basically would apply to all existing construction contracts at the time of the effective date. So if you already completed your construction, right, and your contract, you've basically performed pursuant to your contract, that's the build out is done and completed, it's not going to look back to that work. But if there's a contract, a construction contract that's still in place and the deployment and construction is going on and continues to go on for a period of time, then it would apply. So some contracts that have already been written and signed, but the work has not been completed, in that sense, it's retroactive because it's saying you need to make sure that your contracts have terms and conditions that are consistent with this new statutory requirement.
So you would have to reopen the contract. Is that correct?
If it did not
If it wasn't completed?
If it did not already have, could not be read to already have those protections and standards, yes.
I was under the impression that the problem that they already had those in the contracts. The problem was the contractor goes bankrupt or doesn't have the money to pay for the cleanup, and then it's on to somebody else. But the farmer or whomever is damaged is stuck with the bill. Or and the damage. And in this case, the field where the cow that they hayed from and where the cows got died from. So I think it's given the testimony, it's not retroactive to a already been finished and they're gone and nothing's happened. So that it's just if the contract is ongoing.
I mean, apparently it's already in fact, you have to do all this cleanup anyway, but this would put it in Vermont's law. Is that correct?
I think so, yeah.
It would, and it would add the enhanced enforcement provisions.
Okay.
So you have a private right of action, and you've always had that if there's some injury or harm, just like the, the testimony that you heard. And there seemed to be like an insurance battle, claims dispute going on. Was
Yes.
there coverage? Did they pay? Who's responsible? So I don't think the liability didn't exist. It was just a question of who's going to pay the claim. So that those causes of action exist now and continue to exist, but what you have is enhanced enforcement provisions applicable to injuries.
If you could share a draft copy of the changes to Kyle and Jackie and to the committee members, that would be appreciated. And then we can hopefully dispose of it rather quickly on Thursday morning.
Sure, be happy to do that.
Thank you, Maria. Appreciate it.
Yep, you're welcome.
Thank all of those who've been waiting to hear our conversation about qualified immunity. And we're about 15 minutes late. So we're going to take a 3-minute break just to try to clear the house and let me get some pain medication. We're just going to take a short break. You don't have to close out or anything. We'll be right
Okay.
back.
Okay. We're just taking a 5-minute break, Bradley.
Uh,
Dick,
Yeah,
if we take up that post office resolution, I thought
Yeah.
we were going to do it this week and then it didn't work out, but who would we hear from?
We're
Oh,
live, just to make sure you know.
What? We're
I just-
we
live?
got
We're live.
Oh. Okay.
yeah, we've got a lot of constituents, I'm sure, that would like to speak. I can get you some names of people that have contacted me.
Okay.
What's the resolution about, Jeanette?
The
Post office.
mail deliveries being
Being slow.
inconsistent.
Yeah.
I mean, last week we got 2 deliveries the whole week.
We get ours every single day, right at the same time.
I got my Saturday banner yesterday. Because we didn't have any delivery Saturday. There was a storm,
Yeah.
you know. So there, I can get you some names, I think.
Just a couple.
Yeah, well, one that comes right to the,
Okay.
Yeah.
Okay. I'm sorry, I asked you that. I didn't realize we were live yet.
we're still on YouTube, but that's okay. Glad you're gonna take it up. All right, why don't we get back to taking this up? Peggy, is Brad Meyerson's going to speak this morning or
Yep.
Thursday?
This
Okay.
morning, he's here.
Okay, well, why don't we let Brad start it off and then we'll go to the further discussion.
You're muted, Bradley.
Morning, Brad. You're muted.
Hey, how about
There
now?
you go.
Okay,
You're good now.
all right. Before we start, how much time do I have so I don't abuse my privilege here?
Oh, how much time do you need?
Let's just say I'll try not to abuse the privilege.
How about 10 minutes?
That's fine. That's fine. Senators, for those of you who don't know me, my name is Bradley Meyerson. I live in Pollitt. I recently retired after practicing law in Manchester for 38 years, largely criminal defense and some plaintiff's personal injury. During that time, I handled about 4 to 6 police misconduct cases, 2 of which went to trial, one of which was a plaintiff's verdict and the other was a hung jury. Now, qualified immunity for some reason, and this was going back maybe 30 years, was not an issue in any of those cases. I don't remember why, but it certainly is an issue now. And I would like to start by kind of going maybe a 30,000 feet view of things. Why is this bill being proposed? Why abolish qualified immunity? Well, you're the Senate Judiciary Committee. Your focus presumably is to create just laws based on sound policies to benefit the greatest number of individuals and not to favor a protected class or group of persons. Abolishing qualified immunity would accomplish that very goal of benefiting the greatest number of persons. It's very simple. The bill creates meaningful accountability for a taxpayer-funded arm of government that exerts enormous power and control over the citizenry. It does not create abolishing qualified immunity would not create what is known as strict liability. In other words, you just present your case and you've established liability with putting in a minimum amount of facts. It simply removes the unjust, judicially created doctrine that shields police from the consequences of their own wrongdoing. Now, I'm going to speak to a lot of the objections that I've heard from opponents of the bill, and the benefit of going last year is that going through my notes of what folks had to say at last week's hearing, we heard a lot of alarmists from the law enforcement community telling us that abolishing qualified immunity will open the floodgates to frivolous lawsuits. And since I've done plaintiffs' work, I can tell you, and we've heard that for years from insurance companies when this committee and the legislature as a whole passed laws to broaden claimants' rights or to remove unjust defenses, such as the seatbelt defense. Frivolous lawsuits is simply a bad cliche that is being used in this bill to take away rights of claimants to seek compensation for the courts. There is no evidence beyond, and speculation is not evidence. It hasn't happened in Colorado, which has had qualified immunity for a year, abolished qualified immunity a year ago. There's no evidence that abolishing qualified immunity would somehow, use another cliche, open the floodgates to a wave of frivolous lawsuits against the police. The statute is worded in such a way that it limits frivolous lawsuits because it adopts what's called the English rule, which is that the loser pays. It's if the court, and this I'm referring to subsection D, judgments entered in favor of defendant, a court may award reasonable attorney's fees and other litigation costs reasonably incurred to the defendant for defending any claims the court deems frivolous. So that is a significant check against the fear that abolishing qualified immunity would open the floodgates to frivolous lawsuits. And I'm not wild about this portion of the bill. I understand that there's a reason for it being in there. There are very, very few statutes in Vermont which incorporate the English rule that the loser pays. But I'm comforted by the fact that a court has the discretion to determine whether a lawsuit is frivolous, a lawsuit against police or department or both is frivolous or not. So I think that's a significant check against the possibility of an excessive number of lawsuits. I should also say, from my own perspective of handling these cases and also doing personal injury work, cases against police are hard enough to win even if there is no qualified immunity. It's tantamount to suing a physician in a medical malpractice case. Why? Well, in part because the public, they favor the police, okay? Police officers were taught from, from childhood that they are trustworthy, and deserve our respect, as with doctors. So in front of a jury, a police officer is going to have that built-in respect. And that will be a check, I think, against the success of a potential lawsuit. There is no evidence that abolishing qualified immunity would jeopardize public safety. It hasn't happened in Colorado or Connecticut, which is abolished qualified immunity, nor New Mexico. The civil justice system should be balanced between the claimant and the defendant, in this case, the police or a police department. Police brutality cases, in police brutality cases, that balance, if you have qualified immunity, is fictitious. Police and police departments who employ them have a huge unfair advantage in litigation because of qualified immunity, to the detriment of the victim and their families. And this is wrong. It's morally wrong. It's legally wrong. And abolishing qualified immunity and adopting S254 would eliminate that. If someone is injured due to the negligence of another, the wrongdoer is held accountable through the civil justice system. If a doctor makes a mistake, the doctor can be sued and held accountable by a jury. It's hard to do, but if the injury is aggravated enough and there's liability, the doctor will be held accountable. Why should it be any different when an officer harms a citizen, whether physically through brutality or a violation of constitutional rights by illegally stopping someone, illegally searching them, and as in the Zulo case, which I'm sure you're familiar with, seizing the car and then forcing the person, just leaving them on their own. There is a screening process that lawyers engage in evaluating whether to take a case on a contingent fee, which is how most lawyers would take police misconduct cases. Is the client believable? Am I willing to, do I feel that the case is strong enough to invest in at least one expert, for example, a police misconduct expert, former police officer? Am I willing to risk the possibility of a verdict for the defendant if this bill were to be passed and you've got the loser pays provision? All of those factors make these types of cases very, very difficult to litigate and to win. Qualified immunity, abolishing qualified immunity, will encourage lawyers to represent citizens harmed by the police, whether physically or by egregious violation of Vermont or United States constitutional rights. And it will provide justice by allowing police misconduct cases to be heard by juries, which is something that David Slay pointed out, rather than dying in the crib, so to speak, of being unfairly dismissed before trial by a judge without any discovery to find out the merits of the case. I think it's also going to increase trust in government and the police, because egregious behavior by the police and by the departments employing them will be, they will be held to account. You have, I'm sorry, Senator, you were about to say something. I interrupted you.
No,
Okay.
I'm in a bit of pain, Brad, from some
I'm sorry.
stuff, but no, it's fine. It's not your fault. And I was just sighing from that.
Yeah. There are attorneys, there's an attorney's fees provision for the successful claimant in the bill, which I think is a very good thing. It's not a novel approach because, of course, under the Federal Civil Rights Statute 42 United States Code, Section 1983, there is an attorney's fees component, but it's not automatic. The judge has to find that there's substantial merit to the lawsuit or that you substantially succeeded. You have to have an expert justify the attorney's fees and expenses. And then there has to be a hearing in front of a judge to determine whether an award of attorney's fees and expenses is warranted. I went through that in a successful case that I had, and Judge Billings, who was the federal judge at the time, did cut down some of my attorney's fees and expenses. So it's not an automatic ticket to get your attorney's fees and expenses, even if you win. Plus, under Vermont law, there are attorney's fees awarded in other cases where Senate Judiciary and the legislature as a whole found it a positive social benefit to encourage the filing of lawsuits. In particular, I'm thinking of the construction statute, because otherwise attorneys wouldn't be willing to help homeowners and take those cases on a contingent fee basis. Now, we heard from Sheriff Marcoux and others that abolishing qualified immunity is going to discourage qualified applicants for police positions because they're afraid of being sued. That's a fiction. There is no correlation that's been demonstrated at all between the difficulty in filling police openings currently and abolishing qualified immunity. Manchester recently had 3 officers leave, and just as quickly they hired 2 new officers to fill those positions. If an officer doesn't want to continue in law enforcement because he or she is afraid of being sued, then, or being held accountable for their actions, is this somebody that we really want carrying a badge and a gun and driving a patrol car? I guess taking that argument by the police that it's abolishing qualified immunity would discourage retention of police officers or hiring of police officers. That's really kind of code for saying, well, we should be allowed to relax the standards for hiring police officers. And there is an issue in Vermont about police departments hiring rejects from other departments. Most recently in Woodstock, an officer who was fired by another department was hired by Woodstock. It's happened in Rutland, it's happened in Ludlow, and it's happened in Woodstock. Senator White raised some concerns at the last hearing about insurance issues and indemnification. And this gets into a kind of a broad issue of, well, who's going to bear the loss? Under current law, qualified immunity, since it basically bars citizens from the courthouse door seeking redress against the police, especially the poor and people of color who are most often victimized by the police misconduct. It takes away the remedy for the harms that they've suffered. Stephen Gillum from the Windham County NAACP, he asked you last week, what about the people? He mentioned about how people having bad experiences with police officers suffer post-traumatic stress disorder, among other harms, which also affects their families and society at large. But I believe that this bill will help those harmed by police misconduct who seek compensation for their injuries. And I'm specifically referring to, by taking away qualified immunity, I'm speaking of the indemnification clause in sections E and F. All police are insured. When I tried my first case, actually it's my first civil case, it was a civil rights case against the city of Rutland and 2 officers. The jury returned a verdict against the officers and the city, and they also returned a verdict for punitive damages against the officers. Well, those damages were paid either by the city or by the insurance company. So having insurance coverage, and this goes to the issue of, well, is it an intentional tort? Will there be insurance coverage? There aren't going to be officers losing their homes if they are held accountable by a jury for what they did to a citizen. The indemnification provisions of sections E and F shift the loss for police misconduct to the municipalities and to their insurers. That's what insurance is for. And the departments involving the officers involved suffer the loss also. Those are those entities are better able to handle the losses than the victim.
Could we wrap up, Brad?
Yes,
please?
yeah.
Thank you.
This is a victim's rights bill, I think, above all. You all and your colleagues in the House have spent much time and effort passing legislation to protect victims. This is a victim's right bill. You're protecting victims of police misconduct by giving them the key to the courthouse. It's not an automatic jury verdict for the plaintiff. You are simply helping them achieve justice and accountability for the police. And I think I give you, Senator Sears, tremendous credit, Senator Baruth and Senator Ram Hinsdale for sponsoring this bill. I am sorry that you are taking such heat from the law enforcement community. That's wrong. But this bill is eminently reasonable, and I appreciate your interest in having me testify.
Thank you, Brad. I want to mention Senator Ballant is also a sponsor of the bill.
Yes.
I get, you've raised the specter of the frivolous lawsuit, and I think that's something we all are concerned with. As an attorney, or as a retired attorney now, would you take a case if, unless you were darn sure you could win? Knowing that the attorney fees may, the loser pays.
Well, number of criteria. Number one, there have to be good facts. Okay. Are there witnesses, photographs, injuries? Number two, what's the client like? Do they have a record? Because of course the defense counsel is going to tear them apart. All right. Can they withstand cross-examination? How would they appear in front of the jury? Number three, what experts am I going to need? Where am I going to find them? How much they're going to cost to establish liability on the part of the police? And of course, if there's an injury, I need to have medical experts come in. So all of those factor into the equation of whether or not the case is worth taking. Does that answer your question?
Because we haven't really, we've talked about the frivolous lawsuit and how to avoid them, but we haven't talked about the requirement in the section that outlines the loser pays.
If I felt I had a good enough case, I'd be willing to take it, notwithstanding loser pays. I think that will discourage some, maybe someone who's not familiar with police misconduct cases from taking a case. But even though I'm not thrilled about it, I understand why it's in the bill. It's a counterbalance to the attorney's fees and costs being awarded to the party that substantially prevails. Again, it's not automatic. It's got to be screened by a judge.
Yeah.
Either way.
Thank you. Other questions for Brad? Senator White.
Thank you. Thank you, Mr. Morrison. I do disagree with you on a couple points, and then I have a couple questions, but I disagree with you that this is the only way to hold police accountable. And I think there's a lot of efforts going on right now in Vermont around the Criminal Justice Council and their Professional Regulations Committee to hold police accountable. So I do disagree with you on that. And I'm not so sure that right now in this environment that the public actually favors the police. So I'm not asking a question about that. I'm just saying that I disagree with you on those two things, but I do have a couple questions. One, and I'm not an attorney, so, and I'm just really trying to figure this out. I'm really trying to figure this out and make sure we do the right thing. And I understand that what was told to us in Iqbal, that case, that qualified immunity prevented the discovery from happening. But my understanding is that that case had nothing to do with qualified immunity. It had to do with the federal pleading standard. And that qualified immunity didn't even figure into that. So I'm a little surprised that that was used as an example. And then Colorado only does constitutional violations. This bill expands it to any statutory or common law violations also. So they aren't comparable at all. And this is much more expansive than Colorado. And my question is, I've read a ton of stuff on this, and I've read the Zulu case, and I also read if you Google Zulu, the first thing that comes up, or one of the first things that comes up, is the summary explanation that was given to us by one of our legislative council attorneys. And in reading that and in reading the case, the way I understand this is that, and I know there's a difference of opinion here, but the way I understand this is that the Supreme Court did create a right of action and a right to sue. So I'm a little confused, because when I asked before if there was a different standard that we could use, and if people didn't already have the right of action, the right to sue, that's what I thought Zulu did. And I know there's a difference of opinion, but that was the information given to us by our legislative council. Not Ben, but at a different time on a different case, or a different issue. So I confused. Does it or does it not create a right of action?
Zulu?
Yeah.
Well, Zulu created a cause of action for violation of citizens' rights under the Vermont Constitution.
Right.
Right. What I have dealt with it has been where there's injury, common law torts. So, injury, false imprisonment, for example. Zulu only created that right as pertaining to harms suffered for violation of the Vermont Constitution.
Right. And that's why, and we keep comparing this, saying that it's comparable to Colorado, because Colorado, they haven't seen any increase in suits, and they haven't seen police officers abandoning ship. And that's what Zulu does here. That's what Zulu already does in Vermont. And in Colorado, it is limited to constitutional violations. So I don't understand what.
You're saying that Colorado is not an apt comparison for?
Yes, because it only addresses violations under the Colorado Constitution.
That's a fair point. We're seizing on Colorado as the bright shiny object because they abolished qualified immunity, and they've done that. That's been in place the longest. I think Connecticut and New Mexico were more recent. You could always sue in Vermont. You could always sue a police officer for violation of federal constitutional rights, and for common law torts. It's just that Zulu. Well, maybe I'm wandering off track here. Am I addressing your question?
Well, my question is kind of twofold, I guess. We compare it to Colorado and say, we have not seen a lot of suits, and we have not seen negative impacts from Colorado's elimination of qualified immunity. Colorado eliminated it for constitutional violations, not statutory and common law, just constitutional violations. So comparing it to this bill doesn't make any sense to me, because this is a much broader bill. And my understanding is that Zulu created a right to action for violations of the Vermont Constitution. So if that's already in effect, then I don't understand I don't understand why qualified immunity stands in the way of filing a suit against a police officer for a violation of the Vermont Constitution.
Well, because a violation of, you have to show a violation of a clearly established right.
Yeah, but, and I think that the misinterpretation of clearly established right is,
That is a rule that has been stretched to the breaking point to shield police.
and I don't mean to belabor this, but when I read, there is a 2015 case that says a clearly established right is one that is sufficiently clear that every reasonable official would have understood that what he is doing violates that right. And it doesn't say that it has to be exactly the same. It says that a reasonable official would understand. And that to me says that the way it's being interpreted by people, not necessarily in Vermont and not necessarily in the Second Circuit Court, that they're misinterpreting what a clearly established right is. So what is the standard we should use?
I think you've asked some great questions, and I'm not sure this witness, Brad was here. I'm not sure he's an expert on this.
Well, let me try to answer if you'll have it.
Yeah, I was just that if Jay Diaz or Ben wanted to hop in at this point.
I would defer to them.
But go ahead.
All right.
Pardon me. No, go ahead, Brad. Look,
sure.
Yeah, I just
Senator
found out.
White, I've read, I mean, the example that sticks in my mind of the abuse of the standard is that a case involving a prison, a corrections official, not in Vermont, who maced a prisoner, a defenseless prisoner, causing harm. That lawsuit was dismissed because it was not of the same reason, not same conduct as the case on which it was a presidential case, which was where a prison, a corrections officer punched a defenseless inmate. And the court said, and I don't remember the name of the case. Court said, we're sorry, but that's the standard. And this is being applied all over the country to deprive people of.
I understand that, but that was not in Vermont, and it wasn't in the Second Circuit. And it was a corrections officer. It wasn't a law enforcement officer. So if we're really serious about eliminating qualified immunity for violation of constitutional rights, why don't we apply it to everybody, including us? And I know law enforcement,
meaning the legislature?
Including the legislature.
I remember that discussion last week. You have absolute immunity. Prosecutors have absolute immunity. Judges have absolute immunity. That's not an issue. You can say anything.
I know. That's what I'm saying.
Right.
Why not just eliminate immunity?
Well, here's why. Police carry a tremendous amount of authority. You might not be in office, next November. Or
that's probably true.
You might be voted out of office. I hope not, but police interact on a daily basis with citizens. They carry guns and badges and tremendous authority. And unfortunately, there are officers who abuse that authority and harm citizens.
Yes.
Okay. Qualified immunity is the #1 roadblock to holding these officers accountable. their interactions with the public are different than a legislator or a judge or a prosecutor. It's a different level of involvement, and it's a legal check on abolishing qualified immunity would further the legal checks on their conduct. That's
I
kind of
do.
an awkward analogy, but
I
hope
do understand that, but I just am, most of the examples that are given aren't in Vermont, and they're not even in the Second Circuit. So I'm just, so I realize that, but anyway, those are just my concerns.
What can I say to address those?
Well, you can give me real examples, I guess, of where it's
Senator
been
Baruth. Yeah,
unduly
Senator
used
Baruth.
in Vermont and the Second Circuit.
I'm wondering if, I would like to hear what Jay and Ben.
Yeah, I'm sorry.
No, these are questions that need to be
Bradley,
answered if the bill's going to pass.
Compelling, but I feel like we're basically in
Yep.
an extended one-on-one rather than.
I know. Yeah, sorry.
Yeah, Senator, I'll just finish by saying, I don't have the answers for you as far as Vermont or the Second Circuit. But Jay Diaz,
Jay's letter points out 4 Vermont cases. The letter of 120, I believe they're Vermont cases. Keene versus Schneider, Kent versus Katz, Winfield versus Trottier. Thought there were 4 cases, but I only see 3 here. Jay, do you want to, are you
Yeah.
available?
Please, thank
Yes,
you.
Good morning, all. Happy to answer any questions. Again, for the record, my name is Jay Diaz.
I think the question basically is, what about Vermont cases?
Yes, so Senator Sears, as you just referenced, we noted 3 cases that went up to the Second Circuit, specifically that were Vermont-based cases where qualified immunity resulted in despite the court agreeing that there was a rights violation, the Second Circuit found qualified immunity applied, and so the plaintiffs lost based on qualified immunity. In one of those cases, the plaintiffs, due to their loss on qualified immunity, actually had to pay the defendants, or was ordered to pay the defendants' costs. So it can have pretty serious harms to plaintiffs, even when the court acknowledges and agrees that their rights were violated.
Keene versus Schneider Mr. Keene was questioned in his living room about a possible DUI. Troopers decided to arrest him on suspicion of DUI, later dismissed by the state's attorney, and he refused to go with them. Troopers pepper sprayed him, took him to the floor, and repeatedly punched, elbowed, and kneed him in front of his crying 14-year-old daughter. The district court denied qualified immunity. The Second Circuit reversed granting qualified immunity because the troopers' action did not violate clearly established law without deciding whether the force was excessive. That's one that struck me as particularly egregious, that even the state's attorney declined to prosecute, and yet the person was punched, pepper sprayed, and so forth, elbowed in front of his crying 14-year-old daughter. And even though the district court denied qualified immunity, the Second Circuit reversed it. That is a Vermont case, am I correct?
Yes, that's correct. Yeah, I think it was 2 Vermont state troopers. And I think what this gets to is that there are serious violations of people's constitutional rights, federal and state, as well as their other civil rights, statutory rights, common law rights. And what we find is that in some of those cases, not all, but in some of those cases, if there's not clearly established law, the court is compelled by its prior rulings and precedent around qualified immunity to say, the officer is not going to be held liable here, even though we agree they violated the person's rights, used excessive force, etc. Violated their civil rights, discriminated against them, any of those kinds of things. The court could say, yes, that's true, but because of our doctrine of qualified immunity, which the legislature has yet to say anything about, we are going to protect this officer from liability, or their employer really from liability. And that's what this bill is about. It's about removing that hurdle that prevents people from accessing justice when their rights are violated. When their rights are not violated, if there is no excessive force, if there is no violation of their free speech rights or their equal protection rights, then there's no case. Then the case is over. This bill will only support victims of recognized rights violations and ensure that they get some measure of justice.
Can you speak a little? Senator White believes that Zulu created, what's your impression of that? You heard her questions.
Yes, I'll be happy to talk about Zullo. I was the ACLU represented Mr. Zullo, as I think you know. I was my colleague and I, Leah Ernst, and I represented Greg in a 4 to 5 year case all the way up to the Supreme Court. And what the decision says to me related to this bill is, one, it says, yes, it gives people the right under the Vermont Constitution to sue for constitutional violations. And you don't need to worry about the Tort Claims Act. And I won't go into all that. The bigger, I think, in the confusion is around two things. One, Zullo is unclear at best on the point of whether it's holding around whether plaintiffs can get a damage remedy, whether victims can get justice, essentially, whether that applies to the state only or to the state and municipal employees. So that's left unclear. And that's because there's an absence of legislative direction. The second part, and more importantly, is that what the court laid out as the test for whether victims of rights violations could get justice, could get damages, was based on qualified immunity. It's not the same, but it's a qualified, as this court said, a qualified immunity like test. And we believe that if and that was created in the absence, again, of legislative direction. They acknowledge that they're doing it because we don't have legislative direction. That's the way we're going to go as a court. So it's incumbent upon you all to take to now, I think, invest that time, and as you've been doing, and make some decisions here about how the court should act in these situations. We believe it's very important that people be able to access justice and not have to jump over these hurdles, which are presented by qualified immunity in general and also presented in Zullo.
Thank you. Does that help, Senator White?
I wish I was an attorney, because I really do find it all very confusing. And it is helpful, but I do find it confusing.
Yeah, I'll try to summarize it really succinctly. Zullo does not cover municipal employees. That will have to be decided in later cases. And two, Zullo creates a test similar to qualified immunity that still presents hurdles to getting justice for constitutional rights, Article 11 specifically.
So may I ask one more question, Senator Sears? Oh, where'd he go? There.
He's coming back now. He must have jumped off.
Okay. So what should the should there be any standard at all, or should, should people be able to just sue if they feel their rights have been, I mean, should there be any standard at all? And I guess that's a question for Jay, because you said that Zulo established a different standard, slightly different than the federal standard, but should there be a standard and what should it be? Or should there not be any standard? It's just, and again, I guess, and I know that police officers have huge authority and power over us. But the case that Mr. Meyerson gave was a corrections officer, but we're not including them in here. We're not. So yeah.
So, yeah, Senator White, thank you for the question. I think to answer the question, should there be a standard? We believe that the standard should be, were your rights violated? That's the question that we want to see asked. And that's the question the court has to ask, right? We don't think there should be anything that prevents someone, when the court answers that question, yes, your rights were violated. We don't think there should be this secondary test or this secondary doctrine that says, well, only if they were violated in certain circumstances or certain ways, and the officer knew what they were doing or knew the law, knew they were violating the law. We just think that is beside the point. From a victim's perspective, it is beside the point. And it's what makes victims feel like there's no justice. Because when the court says to a victim of rights violation or excessive force, whatever it is, the court says to the victim, your rights were violated. We agree with you, but you don't get any justice here. You don't get a judgment. In fact, the judgment is against you. And we feel that that's just not right.
I think Dick is frozen.
He looks like he's frozen again.
He does. I know his internet is unstable. Oh,
Yeah.
Dropped out and we'll drop back in.
Yeah. I'd say take over, Senator Bruce.
All right. So 1 second here while I just make sure. Okay. Ben, do you have anything you'd like to add here? You're muted, Ben. Ben, you're muted. Whoop. Can you guys hear me? Okay, Ben.
Sorry, I failed to unmute myself. So for the record, Ben Novogrodsky, Office of Legislative Counsel. I believe I can hopefully lend some clarity as far as the concerns that Senator White raised about, the concept of what Zulo said as far as constitutional actions. Really with that, it was this.
Can I just break in, Ben, just for a second? I keep getting thrown out. So Senator Baruth, please chair the meeting. This is my third time trying to get back in.
Okay, no problem.
Thank you.
Go ahead, Ben.
Sure. It was this concept of, and Senator White, you were correct to the degree in that the Supreme Court said that there are certain constitutional provisions that are quote unquote self-executing, that have an implied private right of action that you can bring in a court for remedy. However, the next step or a part of that analysis was, even if you could bring an action, it was whether or not damages were a proper remedy under the action you could bring. And part of the way that this bill was drafted was to encapsulate or reflect that language, in the sense that the bill's language kind of contains this self-limiting language as far as constitutional actions, where it says ones that provide a private right of action. What this bill would do was just attach a damages remedy to those actions that you can already bring, but the Supreme Court said without legislative direction, essentially, that if there's another remedy for those violations, they'll look to find it. This bill is to provide direction to say that the remedy to be had is damages or money. So that's part of that. So you were correct in the sense that you could bring them, but this lends clarity as to what the result or remedy would be in those circumstances. And then, so I think that was a point of confusion. Does that lend a little bit of clarity as far as those constitutional violations?
It does, thank you. And I guess, what other remedy would there be?
Well, in that case specifically, the state put forth a bunch of different alternatives. So you could do injunctive relief. So basically saying that the state is prohibited from stopping vehicles that had covered registration stickers. They could say that you could bring an action under the federal statute, section 1983. But as we've discussed, the federal constitution, the Fourth Amendment, differs than our Vermont equivalent.
Right.
The Vermont one provides broader protection. So not all alternative remedies would be adequate necessarily. And so this is designed to just, I think, give consistency as opposed to where the courts have discretion on a case-by-case basis to decide one way or the other. And I think that also goes to the clearly established right issue that we were discussing earlier as well, is that, you're correct. I mean, this is derived from Vermont case law in the sense that, clearly established law just means that the contours of the right are sufficiently clear that a reasonable official would understand that what they are doing violates that right. That is what you quoted before. But it's been interpreted that, any lawyers love to debate. And I think that, again, this is to provide consistency for the courts, as opposed to the courts navigating it individually themselves. And, so the purpose of this is to give some legislative direction to say that these are the rights that can be brought, and this is the remedy that can be sought, as opposed to the courts trying to do the analysis themselves on a case-by-case basis, trying to find similar circumstances to apply to a new case before them.
So our agenda says committee discussion and next steps, and we're coming up on noon. We have about 15 minutes left. Senator Sears, do you want to go there at this point?
Well, I think Senator White has, raised some important issues, not the least of which is some confusion about different cases. And I don't know if there's somebody who would like to speak from the opposition side on those issues. We've heard from our alleged counsel. We've heard from proponents of the legislation, Jay Diaz and Brad Meyerson. So I don't know if somebody would like to comment on the other side. Wilda, would you like to comment?
Wilda White. Tucker Jones is here, who works for an attorney for the Department of Public Safety. Maybe we can tag team and Tucker can talk about the cases, and I can comment on other issues. I would, and perhaps I'll start with. I'm speaking. I have Mad Freedom, the organization I founded, is opposed to this bill, and I've been speaking here as also a policy consultant with the Department of Public Safety because our interests and concerns about the bill are aligned. And what I'm going to say now, I haven't run it by anybody, but I think it's important for this committee because these other bills from other jurisdictions were raised to understand a little bit about what those other bills have done. And so I'd like to actually address that because I have talked about how this bill differs considerably from what other jurisdictions have done. And Brad Meyerson alluded to those bills, and I'd like to give you a little bit more detail about that, if I may.
Yeah, we've got about 10 minutes, so.
I'll do it in less than that. Okay, so I've talked about
Okay.
Colorado's bill. So, it's limited to constitutional violations of the Colorado Constitution. It has a mandatory attorney's fee provision. It has a 2-year statute of limitations. And so I've talked about that. But what I'd rather talk about now is New Mexico and Connecticut. New Mexico particularly, I think, is a great example of good bill drafting. New Mexico eliminates qualified immunity for all government officials. They also have limitations on liability. So like per occurrence, it's $2 million and it goes up with inflation. That's responsible legislating. They also have a notice of claim provision. So with 1 year of being injured, you have to file a notice of claim with the government. That way the government can actually manage the risk, right? Because that's what you want to do. The more information you have, the more you can manage uncertainty. That's responsible legislating. They also have an explicit provision in the bill that it's not retroactive. Very responsible legislating, because under this current bill, you haven't said one way or the other. Clever lawyer.
Well, I take exception to being called irresponsible.
I'm
okay?
sorry, you should.
And that is very offensive to the chair, to the vice chair, and other members of this committee, Wilda. I don't know that you can say that we're irresponsible.
I don't mean to
outrageous.
say that you're, Senator Sanders, you are right to correct me if you feel like that's what I'm saying. I am not saying that. What I'm saying is here is a bill that I think represents responsible legislating. You haven't passed any bill. You are looking at this and you're inviting people to comment to get to the best thing you can do. I wouldn't say you're responsible legislators. You haven't even passed anything, and that is not my intent of doing so. I welcome the fact that you've invited us to speak here, and that's all I'm trying to do. And I apologize to anybody who thought I was contrasting your proposed bill, which you haven't passed on, to these past bills. So thank you for correcting me, because I don't want you leaving with that impression. It wasn't what I was trying to say.
Appreciate that. Thank you.
You're welcome. And the other thing that the New Mexico bill doesn't do, it doesn't abrogate all immunities, right? It only changes the qualified immunity. It doesn't change the statutory immunities or other immunities. It's very limited. And then the last thing, it does have it does provide for an indemnification provision. It makes clear that any officer sued under the bill would be entitled to both legal defenses and the judgment. And then in terms of Colorado, it's also limited in terms of, and the last thing they do is you don't have to pay if the officer has to reimburse, so I'm gonna go to, actually, I'm gonna stop and let Tucker talk, because I know you're pressed for time. If you want to come back to Connecticut, I can talk about Connecticut.
I appreciate that. Thank you.
Hello, everyone. Hello, Chair Sears, Senators. My name is Tucker Jones. I'm Assistant General Counsel at the Department of Public Safety. Chair Sears, would you like me to speak now in response to your earlier question about this concern regarding Zulo?
We just lost Senator Sears again.
Absolutely, Tucker. We have only about 5 or 6 minutes for you, but please go ahead.
Sure. Thank you, Chair Bruth.
Vice Chair Bruth.
Vice Chair Bruth. Okay. So I've been studying this issue for quite some time, and I've been following the committee testimony and discussion about this. And the Colorado bill and law ending qualified immunity, expressly created a cause of action under the Colorado state constitution, including its own search and seizure provision there. And your legislative counsel has explained this in the memo comparing the two bills about how it does that. The Vermont Supreme Court had already done that. They had already created a cause of action under the Vermont search and seizure provision in 2019. It's largely considered like a landmark case. It's 85 paragraphs long. It's a unanimous decision by the Vermont Supreme Court. They explicitly, and this is of what's particular relevance, I think, for this committee, is that they explicitly created an alternative to the federal clearly established standard. And they provided that a plaintiff may show that an officer acted in bad faith. They defined bad faith, which as something that may exist when an officer's conduct could be viewed as objectively reasonable, but is characterized by ill will or wrongful motive, including discriminatory animus. When you Google this case, as Senator White alluded to, the second entry, I think, is a summary of the case by what looked to be legislative counsel, I think Eric Fitzpatrick, just kind of summarizing the whole case in about 6 pages. And there's a note in there underneath this alternative standard. It says, note, this was a rejection of the United States Supreme Court's approach under the Fourth Amendment, since the United States Supreme Court had held that the officer's bad faith is otherwise irrelevant if there is a neutral and reasonable basis for the search or seizure. I would consider this decision critical to understanding the legal landscape surrounding qualified immunity in Vermont, because it's important to understand that the bad faith showing that a plaintiff may make under a claim under Article 11 is an alternative to the clearly established federal standard, the clearly established standard that has been criticized by national, social, and legal commentators. And it's just very important for this committee to understand that we already have a cause of action under the state constitution. And the unanimous Vermont Supreme Court considered these issues in quite a bit of detail. They considered whether it was appropriate to have some limitation akin to qualified immunity, and the unanimous Supreme Court considered that it was appropriate and necessary to do so. And I think that's just a very important thing for this committee to understand, that the Vermont Supreme Court has already weighed this issue, and they thought that some protections akin to qualified immunity were appropriate, but they provided an alternative to showing bad faith by an officer from their discriminatory animus or otherwise. And this is a key point, because the reason some version of qualified immunity is appropriate is because the courts want to ensure that the government employee is on fair notice that their conduct is violating the Constitution when they engage in that conduct. And the Supreme Court discussed this by specifically highlighting how this affects law enforcement officers operating in the field. And I think it would be helpful to explain this. They said, having no protection akin to qualified immunity could create a potential flood of litigation for every alleged constitutional violation. That's not my language. That's a unanimous decision by the Vermont Supreme Court. That's their language. We're just letting you know that that language exists. And then they go on to say, on a daily basis, law enforcement officers must make numerous decisions on how to handle interactions with the citizens, particularly motorists, even with liability falling on the state rather than the individual officer. A rule that exposes the state to a potential civil damages suit following every roadside stop or whenever a motion to suppress is granted could inhibit law enforcement officers from taking some effective and constitutionally permissible actions in pursuit of public safety. This would not be an appropriate result. One of the highlights of this paragraph, and they say it in passing, is that whenever a motion to suppress is granted, and what they're referring to there is on a regular basis, trial courts, criminal courts in our state grant motions to suppress, which by their very nature state that an officer's actions were in violation of the Constitution. Now, there is no indication in those motions to suppress that are granted that the violations are necessarily anything other than a mistaken but reasonable belief by the officer that their conduct was appropriate at the time. But what we would be doing by eliminating qualified immunity is allowing a civil lawsuit for potential of attorney's fees following every single motion to suppress that it's granted in court. Because by its very nature, those decisions are stating that the officer's conduct was unreasonable. And as the Vermont Supreme Court indicated, that is that's not an appropriate result, because it would result in a flood of litigation after every single one of those cases, potentially. But it would also inhibit officers from carrying out their duties that we ask them to do, because they would be concerned about a potential civil suit every time a criminal court grants a motion to suppress. So that's the legal considerations that the department views around this bill. There's many, many other considerations, but I know we're out of time for today. And we welcome the opportunity to discuss that further.
Okay, well, we'll give you that opportunity on Thursday morning. But what was the name of that case?
That's Zulo v. State, 2019 VT1 is
Okay,
the.
so that you're quoting from Zulo, which has created a great deal of confusion. So why don't we pick up there on Thursday morning? And I apologize to everyone, and especially Wilder, if I was a little bit overly sensitive about the irresponsible versus responsible language. Perhaps I was a bit oversensitive.
Senator Sears, I appreciate you bringing it up so that I can address it. So thank you.
Thank you, Senator White.
I appreciate your indulgence. Thank you for my questioning.
We'll pick up there on Thursday. I thank all of you. And I'm sorry that I kept getting thrown out of the meeting. This has never happened before in Zoom. That's like 4 or 5 times I was removed from the meeting. I don't know if people knew I was gone, but so I missed some of the conversation. So I hope we can, what's that?
You know something, Senator Sears? The role of the constable is to keep order in the town meeting and stuff, and to kick people out if they're being unreasonable. Do you have constables in Bennington? Maybe that's what's happening.
That might be, but I don't even think I was saying anything.
No, you didn't have to be.
But I got kicked out.
No, you didn't
I
have
just
to be.